Thank you so much for joining us today. The topic we will be discussing is communicating with clients in a compliant manner. Before we start our session, I request you to save your questions until the end. Also, please note that Alison Guy will not be presenting today. Instead, Jared Smith will be replacing her. Please also take a few seconds to review our standard disclaimer. The agenda today will walk through marketing materials, KYC documentation process, RDIs, client statements, and the use of disclaimers in documents. Each of these is directly used to communicate with clients. We will end the session with tips on how you can strengthen your compliance systems to specifically address these areas. We want to remind all registrants that we expect you to conduct yourself in a manner that is consistent with the principle of securities regulation. This requires all market participants to respect not just the letter of the law, but also the spirit of the law. When reviewing client communications for compliance with securities law, we rely on specific rules and instruments. These rules require registrants to deal fairly, honestly, and in good faith with their clients. They also prohibit any person or company from making statements that are untrue or omitting information that is necessary to prevent the statement from being false or misleading. The use of different types of marketing material is key in communicating with prospective clients. We will walk through issues noted in different types of marketing practices used. We have noted certain inappropriate practices with the use of testimonials, such as the use of false or misleading testimonials, example, a person providing that is no longer a client, or the testimonial is being provided by an individual who is being compensated for this, however, that fact is not disclosed, or a testimonial that omits certain information that may be important to the end user, such as if it was from a decade ago. It can also include unsubstantiated information. Here is an example of an inappropriate testimonial used in marketing material. As you can see, Constable Doe claims that he trusts firm XYZ Financial Inc. The firm has helped diversify and protect his investments and has continually provided an 8% annual return. The issues we noted in this example are that there is no way of telling that this testimonial is from 8 years ago. Constable Doe is no longer a client of the firm. The firm has ceased to offer some of the products that the client was invested in. It implies a minimum guaranteed 8% return, which is not allowed. The returns provided are unsubstantiated, as it does not state how many years this relates to or if there's a gross or net return. Finally, there's no disclosure to inform the readers that the testimonial may not be representative of the views of others. If using testimonials, registrants should ensure that these are current. Clear disclosures should be provided if it has been solicited. Disclosure should be provided that the views presented may not always be representative of the views of others. Any disclaimer provided should be clearly readable, in close proximity to the testimonial, and should be understandable to readers. The registrant should ensure that they have adequate information about the individual providing the testimonial, including their consent to use it. And there should be policies and procedures to appropriately review these and to ensure that it is not misleading. We have often noted that certain marketing materials can include statements that cannot be substantiated and/or may be exaggerated. There are two examples of claims that are unsubstantiated but may not be obvious to the reader. The first claim is, we rely on our expertise to make the best decision for our funds, while also utilizing the collective skills and experience of other asset managers to achieve the best possible investment outcome. Best possible investment outcome cannot be substantiated, and given the number of possible investment outcomes, this may almost be viewed as an exaggerated claim. The second claim states that our fund provides high income with low volatility. This statement would be acceptable as long as there is accompanying performance numbers and standard deviation information to substantiate this claim. The rule of thumb for all registrants should be that if you cannot verify a particular claim, it may be inappropriate to use. We have seen registrants use performance of a past firm to market another firm. However, these may be inappropriate, especially if the individual at the new firm was not responsible for generating those returns, and or if the investment strategy is different from that being used at the new firm. If we look at the example provided, Mr. Mann was the founder of a successful firm, Firm Old Limited, which he sold. Given certain facts, it is inappropriate for Mr. Mann to use the performance to market his new firm. At Firm Old Limited, the team making the decision comprised of 3 advising representatives, including Mr. Mann, and 5 analysts. None of these individuals will be employed at the new firm. Therefore, the team was actually responsible for generating the returns, and therefore it would be inappropriate to market those returns. Firm Old Limited also managed 3 global hedge funds, whereas the new firm is focused on providing discretionary advice to high net worth clients with a focus on North American large cap equities. This is clearly a different strategy. In our view, it is misleading and not relevant to market the returns from the previous firms in this case. There are limited circumstances where it may be appropriate to market the performance of a previous firm, but all the conditions listed have to be met. The key investment decision maker at the previous firm should be at the new firm. The investment strategy at the previous firm should be substantially similar to that of the new firm. The new firm should have the books and records to support the historical data presented from the previous firm, and there should be adequate disclosure that the performance presented is from a previous firm and any other relevant facts. When we see marketing materials that use hypothetical data, some of the concerns that we have are that many investors may not have the sophisticated investment knowledge to understand the inherent risks and limitations of this data. Any outcome may be achieved with the benefit of hindsight, and the data is subject to potential manipulation. The data is often combined or linked with actual client performance data, which is misleading. There's inadequate disclosure regarding the methodology and assumptions used to calculate this information. Increased risk can be taken with the creation of these portfolios, as these are not managed in real market condition. It is difficult to verify the calculation of the data, and trading and other costs are not always deducted, and if they are, they're usually an estimate. We often see vague disclosures that accompany the hypothetical data used. In this example, the disclosure states, the average asset class hypothetical returns are based in part on gross historical returns of certain indices. It does not specify what these indices are. Further, it goes on to say, and in part on our predictions for the stated asset class's future performance. Again, it does not provide the assumptions and the calculation methodology used in predicting the stated asset class's future performance. It goes on to say that they represent the weighted average of the hypothetical future returns for the individual major indices assumed to reflect the asset classes. The remaining portfolio statistics are then derived from this hypothetical information. Again, it does not disclose the inherent risks and limitations of the hypothetical performance data. On this slide, you can see an example which links actual performance data with simulated data. The graph appears to present the returns for the U.S. Bond Fund II. However, when you read the notes, the returns of the U.S. Bond Fund II are only from December 2011 to date. The previous returns are that of a fund that has been wound down and simulated returns. The issue we have with presenting returns in this manner is that it is confusing to investors. It gives the perception that the U.S. Bond Fund II has a longer track record than it actually does. It's unclear how the simulated performance is calculated, as assumptions and calculation methodology has not been provided, and unclear what the difference in strategy is between the U.S. Bond Fund I and Bond Fund II. One thing to note is that even if the notes were detailed and fulsome, it is still not acceptable to link actual and simulated data in one chart. These should be shown separately. There are instances where it may be acceptable to use hypothetical data, but in those instances, we expect that the presentation be restricted to investors known to have sophisticated investment knowledge. so the registrant has to verify the investor's knowledge prior to the presentation. The presentation needs to be labeled as hypothetical in a clear and prominent manner. As mentioned before, there should be no linking between actual and simulated returns. Clear and meaningful disclosure should be provided regarding the methodology and assumption used to calculate the data. And it should disclose clearly the inherent risks and limitations of the performance data. If registrants choose to use benchmarks, the registrant should compare their performance returns against relevant benchmarks. In most cases, this means that there should be a significant degree of comparability and similarity between the investment strategy and the benchmarks used. If not, the concern is that investors may infer an incorrect conclusion from the comparison, or it may appear that a strategy is performing better than it actually is. In limited instances, it may be appropriate to compare performance returns against a benchmark that has a different composition to that of its investment strategy. For example, a registrant may compare its strategy to the S&P TSX Composite Index or the S&P 500 Index. In these cases, we would expect relevant disclosure to be provided. Here is an example of an acceptable disclosure, as it clearly outlines the relevance of the benchmark, a discussion of the difference between the benchmark and the investment strategy, and the reasons for using the benchmark. We have also noted in some cases that a firm may not be accurately stating their registration with securities regulators. For example, they may state that they're registered with the Ontario Securities Commission, but they do not state the category of their registration. Or they may state that they're registered with the OSC as a portfolio manager when they're actually registered as a restricted portfolio manager. They may not also clearly state in which provinces or territories they're registered. For example, if there's a firm that's registered as a portfolio manager in Ontario and an EMD in Alberta, BC, and Ontario, and if the disclosure states that the firm is registered as a dealer and portfolio manager in Alberta, BC, and Ontario, this is misleading because an investor is led to believe that the firm is also registered as a PM in BC and Alberta, which is not the case. So what can you do right now? You can review CSA Staff Notice 31325 Marketing Practices of Portfolio Managers. Please note that although the guidance specifically refers to portfolio managers, it actually is a guidance that's applicable to other registrants as well. You can also review the OSC Staff Notice 33747 Annual Summary Report for Dealers, Advisors, and Investment Fund Managers. This specifically discusses the use of testimonials and marketing of registration. You could also complete a self-assessment of your marketing materials for language or performance data that is misleading or confusing, or language that is not substantiated or for which you do not have appropriate support. If you identify inappropriate or misleading materials, take action now to rectify the non-compliance. Make sure you document the action you've taken. Collecting KYC information is a key process where registrants communicate with clients. This conversation occurs at the onset of the relationship, and it is critical for the communication to be clear and comprehensive. In this section, I will not be addressing KYC and suitability obligations. Please refer to the Registrant Outreach session dated December 11, 2013 for further information on this topic. The purpose of this discussion is how to communicate with clients clearly regarding the KYC forms. We have noted that it is common practice for firms to use a checkbox format to obtain certain KYC information. However, it is our expectation that the registered representative should be explaining to clients what each question means and that this discussion should be documented. It is also important for representatives to be mindful of the type of investors that they're dealing with when obtaining this information. Investor types that are particularly prone to vulnerabilities could be senior citizens, individuals with diminished capacity, individuals with limited investment knowledge and experience, and those for whom English is a second language. Our expectation of representatives is that they should clearly explain to investors certain terms that may not be adequately defined. We have seen examples where for investment objectives, one of the responses provided is other. We expect that a meaningful conversation be held between the representative and the investor to understand what the objectives defined as others is, and this should be clearly documented. There are also certain terms used in these forms that may be subjective, such as short, medium, long-term horizon. The representative should obtain what the client's view of, for example, a short-term horizon is, 3, 5, 7 years, and determine if it aligns with the firm's view of a short-term horizon. This too should be documented. Registered representatives should also not assume that a client understands a commonly used industry term. We often see registrants rely on the net financial asset test to determine if a client meets the accredited investor definition. However, representatives need to clearly explain to the client what is meant by net financial asset. For example, the investor should be explained that real estate cannot be included in the calculation of net financial assets. So what you can do right now is complete a self-assessment of the KYC forms you provide to your clients and determine if the language is unclear or if certain terminologies need to be defined better. If the clients have checked off vague terms such as other without an explanation being included as to what other means, and take steps to rectify any issues noted. This could include updating documentation for a client and or updating the KYC form to make it clearer. You should also ask representatives that collect the KYC information if they explain the terms in the KYC forms to clients, and if they consider the client's age, mental capacity, and investment experience when communicating with clients. I will now pass it on to Teresa Demata, who will discuss RDI documents and client statements.
Thanks, Alize. Before I begin with the relationship disclosure information, I just wanted to mention that although we asked you to save your questions until the end, please feel free to submit your questions throughout the webinar and we will answer them at the end. So now we will be discussing relationship disclosure information. The next area of focus will be on relationship disclosure information, which is a requirement under Section 14.2 of National Instrument 31-103. The information that is specifically required to be disclosed is outlined in paragraphs A through to M of subsection 14.22 of National Instrument 31-103. The RDI requirements are applicable to all PM and EMD firms. However, firms are not required to provide RDI information to permitted clients that are not individuals, such as pension funds and investment funds. The RDI requirements were established to provide clients with a better understanding of the registrant-client relationship and to enable clients to make informed decisions. So the RDI provided to clients should be clear, meaningful, and understandable. We expect registrants to spend sufficient time having meaningful conversations with clients regarding the RDI disclosures and to explain the information that is being delivered to them. When having these discussions, registrants are encouraged to avoid the use of technical terms and acronyms which may not be understood by the average investor. In terms of delivery, registered firms are required to deliver the RDI information to clients at account opening, prior to purchasing or selling a security for the client, or prior to advising the client to purchase, sell, or hold a security. There is no prescribed form for RDI, so registered firms may choose to provide this information in a single document or in separate documents which together provide clients with all the required RDI information. At this point, we would like to go through some of the common deficiencies we come across when reviewing RDI disclosures. The following slides list the prescribed RDI paragraphs, and the chart to the right shows which paragraphs are commonly raised as deficiencies and which firms, PMs, or EMDs we commonly see these deficiencies in. As noted in the chart, we do not typically find deficiencies in paragraph A, so I will move on to paragraph B, which requires firms to describe the products or services offered. We don't typically see a deficiency in this paragraph for PMs. However, for EMD firms, we usually find that they do not indicate the different types of products offered. EMDs should also indicate that the products are not offered by way of prospectus, rather than just indicating that they sell exempt products. This is an example of acceptable disclosure under this paragraph, and I will give you a few seconds to read it. The examples provided in this section are also included in slide decks on slides 34 to 36, which will also be available on our website, so you can make reference to them at a later time. Moving on to paragraph C, which requires firms to describe the types of risks a client should consider. Here we find deficiencies for both PMs and EMDs. We usually find that firms provide a list of risks that are generic and vague, and we've also seen some firms simply state you may lose all of your investment. For PMs, we would expect the risks described to be relevant to the investments offered and the investment strategies recommended for clients. For example, the risks disclosed by a PM firm that has a buy and hold strategy and invests in large blue chip securities will be different than the risks disclosed by a PM firm that uses investment strategies such as short selling or derivatives and invests in startup companies. For EMDs, we would expect firms to describe the risks of investing in the exempt market in general, in addition to explaining the specific risks of each product. If an EMD refers to the risk disclosure contained in the issuer's offering document, we would expect the firm to review the disclosure to ensure that it is adequate and captures all the risks associated with investing in that product. Paragraph D requires firms to disclose the risks of using borrowed money. This is a common deficiency for PMs. Some PM firms incorrectly assume that this requirement does not apply to them because they do not purchase investments on margin, or they do not recommend leverage strategies to clients, or simply because they do not accept clients who borrow money to invest. Regardless of whether the client uses leverage or the firm recommends the use of borrowed money to purchase investments, this disclosure is important and is a requirement because the PM or EMD firm may not be aware that the client is making an investment with borrowed funds. And this is an example of acceptable disclosure pertaining to this paragraph. Moving on to paragraph E, which requires firms to describe the conflicts of interest. This is a common deficiency for both PM and EMD firms. Some PM firms say that we are independent and not related to any other entity, therefore they do not have any conflicts of interest. Some EMD firms rely on the issuer's offering document, which may not necessarily describe the conflicts of interest of the EMD firm itself. Most PMs, even those with no related entities, have some conflicts that require disclosure, such as soft dollar arrangements, fair allocation, and personal trading. If PMs determine that they do not have any conflicts of interest that require disclosure, they should maintain written documentation to evidence that they have considered this issue. For EMDs, the most common conflict of interest is the compensation received from issuers and the conflicts that arise when selling securities of a related or connected issuer. EMDs may rely on the issuer's offering document for this disclosure, provided that the EMD has reviewed the disclosure and is satisfied that it adequately describes the conflicts of interest and they are reflective of the firm's conflict of interest. It is uncommon to find deficiencies in paragraph F, so I will move on to paragraph G, which requires firms to disclose transaction charges paid to the firm. Transaction charges are defined in section 1.1 of National Instrument 31-103, and some examples include, but are not limited to, commissions, transaction fees, switch fees, performance fees, and redemption fees. We have found that this paragraph is a common deficiency for EMD firms as they typically fail to disclose the commission or transaction fees charged to clients. Paragraph H requires disclosure of the compensation paid to the registered firm. This is a common deficiency for EMD firms given that they do not always disclose the compensation paid to the firm, including any commissions they may receive. Paragraph I requires firms to describe the content and frequency of reporting. This paragraph is often raised as a deficiency for EMDs. We have found that some EMDs only disclose that they will be providing clients with trade confirmations and fail to state that clients will also receive quarterly transactional information and, in some cases, account position information. We encourage EMDs to assess their reporting obligations and review CSA Staff Notice 31-345, which is the frequently asked questions on cost disclosure, performance reporting, and client statements for further guidance. And this is an example of acceptable disclosure pertaining to this paragraph. So moving on to paragraph J, which requires firms to disclose their obligations if a client has a complaint contemplated under section 13.6, which is dispute resolution service. We usually raise this paragraph as a deficiency for PM firms, as their disclosure is sometimes simply states that they are a member of OBSI. To satisfy the requirements of this paragraph, the disclosure should include the method in which a client can report a complaint, for example, in writing, email, phone call, and the person they should be addressing the complaint to. The disclosure should also include a high-level description of the firm's process in addressing complaints and the firm's obligation regarding complaints that involve OBSI. And finally, the disclosure should include the availability of OBSI to the client at the firm's expense and the contact information of OBSI. Paragraph K requires registered firms to disclose their suitability obligation. We usually raise a deficiency in this paragraph for PMs. Some firms think that it is sufficient to state that they will manage client accounts consistent with the client's KYC information and investment objectives. However, we would expect PM and EMD firms to explicitly state that the firm has an obligation to assess suitability of a transaction or language that is materially similar to it. And this is an example of acceptable disclosure pertaining to this paragraph. And finally, paragraph M requires registered firms to disclose information regarding the use of benchmarks. We typically hear from registrants that they do not use benchmarks, and therefore they do not feel that this requirement is applicable to them. However, even if the firm does not use benchmarks, this paragraph requires firms to provide clients with a general explanation of how investment performance benchmarks might be used to assess the performance of a client's investments. Other than this general discussion, there is no requirement for registered firms to provide benchmark information to clients. However, if the registered firm does use benchmarks, then the disclosure under this paragraph should be more detailed and explain which benchmarks are being used and any relevant differences between the benchmark returns and the client's investment returns. For example, the benchmarks do not factor in the costs of investing. And this is an example of acceptable disclosure pertaining to benchmarks. The following slides are examples that we just went through and are available for your reference in the slide deck. I will not go through these examples now, but as I mentioned earlier, the slides will be made available on our website for your future reference. So what can you do right now? Review the RDI requirements set out in section 14.2 of National Instrument 31103. Complete a self-assessment of the RDI disclosures you provide to clients to ensure that paragraphs A through to M of subsection 14.22 of National Instrument 31103 have been addressed, and to ensure that your RDI disclosure is tailored to your firm's operations with respect to, among others, the products or services you provide, the types of risks clients should consider, conflicts of interest, and the costs your clients will incur. We will now move on to client statements. The focus for this section will continue to be on client communication and not on the CRM2 requirements. For the CRM2 requirements, please refer to Part 14 of National Instrument 31103 and its companion policy, or CSA Staff Notice 31345, or the OSC outreach session held in April of 2015. In this section, I will go over some of the more common deficiencies we find with client statements. Client statements have two principal elements, transactional information and account position information. Transactional information is required in almost all cases where there has been a transaction, and the account position information is a snapshot of the whole account. In terms of delivery, client statements are to be delivered to clients once every 3 months or monthly if the client requests. We remind registrants that client statements may also be delivered electronically, and guidance on electronic delivery can be found in National Policy 11201. With respect to form, there is no prescribed form for client statements, but there is prescribed content that can be found in sections 14.14, 14.1, and 14.2 of 31103. Next, we will be going over some of the common deficiencies we raise with respect to client statements. We typically see account position information, but no transactional information being provided in client statements. As previously mentioned, client statements may have to include both transactional and account position information. This is true whether you are a PM or EMD. We often find that firms only provide client statements with account position information and not transactional information, or vice versa. Be sure to review the client statement requirements in National Instrument 31-103 and CSA Staff Notice 31-345 to determine what information your firm is required to include. The next common deficiency on client statements that we see is the market value of securities based on closing prices instead of last bid ask price. This is okay only if the firm performs a periodic assessment which shows that the closing price is materially the same as the last bid ask price. During our compliance reviews, we found that firms use the closing price as the market value of securities without having performed the periodic assessment, and therefore a deficiency was raised. Moving on to consolidated statements. Some firms provide clients with consolidated statements which combine the security holdings and transaction information of more than one account they manage for a client into a single summary statement. For example, the firm may consolidate a client's taxable account with a non-taxable account, or consolidate based on family accounts, such as spouses and dependents. However, firms are required to provide a client statement for each account they manage for clients. Having said that, it may be appropriate for firms to deliver consolidated statements to clients when it is provided as supplementary information. If firms decide to provide consolidated statements, we encourage you to review the suggested practices outlined in Section 5.4.1 of OSC Staff Notice 33-738, which is the 2012 OSC Annual Summary Report for Dealers, Advisors, and Investment Fund Managers. The next deficiency commonly raised relates to inadequate disclosure of the definition of book cost or original cost. These definitions can be found in Section 1.1 of National Instrument 31-103. We have found that most client statements now contain the required position cost information. However, some firms do not always provide the required definition of book cost or original cost. Firms are also not always disclosing the party responsible for holding securities and a description of the way securities are held. Or we have found that some firms have disclosed the party that holds client securities, but fail to disclose the manner in which they are held. Here we would expect to see disclosure along the lines of, your securities are held with ABC Custodian and they are held in your name. What you can do right now: complete a self-assessment on the client statements you deliver to clients. Ensure the client statements include the required information. Remove any disclaimers that appear to lessen your obligation to provide accurate and complete client statements, such as, although we have obtained the information in this report from a reliable source, we cannot guarantee its accuracy. And finally, ensure your full legal name is on the client statements, as opposed to only your trade name. And now I'll pass it along to Jared, who will be discussing disclaimers and an effective compliance system.
Thank you. Thank you, Teresa. So now I want to spend a few minutes talking about disclaimers. This is an area where we commonly find firms are non-compliant with securities legislation. To begin with, what do we mean by disclaimers? We consider disclaimers to be language in documents or agreements which purport to limit a registrant's liability to their clients. Often people refer to them as hedge or disclaimer clauses. The documents, with the disclaimers included in them, are given to your investor clients. We have found disclaimers in Know Your Client forms, risk disclosure forms, client statements, investment management agreements, and offering memoranda. More recently, we have also started to see disclaimers appearing on firms' websites. You cannot contract out of requirements under securities laws. During a compliance review, we will review and assess your documents or agreements for any language which might be inconsistent with your duty to deal fairly, honestly, and in good faith with your clients. As Alize mentioned at the start of today's session, this is one of the principal regulations for communicating with clients. Because of the nature of the more common disclosure clauses, we may also be assessing your documents for language which might be inconsistent with your suitability obligations. On the next few slides, I have provided a few examples of disclaimers which are non-compliant with securities laws. We have provided these examples to help you have a better understanding about disclaimers. Here are 3 examples which show you language that is attempting to limit the firm's liability for losses on investments and to take away from investor clients some of their rights. The intent of these disclaimers is to protect the firm no matter what happens, no matter what the facts of the situation really are. This intent is at the expense of the investor client. In and of itself, the intent to take something away from an investor client is not demonstrating that you are dealing fairly, honestly, and in good faith with your clients. We do not encourage the use of any terms and agreements that seek to limit or qualify a firm's liability to its clients. There is also doubt as to the enforceability of a contractual provision purporting to have these effects. Moving on this slide we have provided 2 examples of disclaimers which are completely inconsistent with a firm's suitability obligations under securities legislation. The first disclaimer specifically says the firm does not warrant or guarantee that any offering will be suitable investment for the client or reflect the client's investment goals. And the second example provides that the firm is not providing any investment advice or opinion concerning the security offerings. Both of these examples of disclaimers are unacceptable as they contradict a firm's suitability obligations under Section 13.3 of National Instrument 31-103. Lastly, I want to show you an example of an inappropriate disclaimer which may not be as obvious. These 2 example disclaimers on this slide were actually included in documents drafted by issuers. The registered firms involved then distributed the issuer's documents to their investor clients. It is because there is a registered firm involved in this transaction that these disclaimers are not appropriate. The disclaimers are contrary to the registered firm's obligations. So please remember that we will look at all the documents that a registered firm provides to investor clients for any language that might be inconsistent with the registrant's obligations under securities law. Where we have found cases of inappropriate disclaimer language in documentation provided to investor clients, we may also say the clause or term is a deficiency in a compliance review. We will require you to take action to address this matter. We will also ask for the disclaimer language to be removed from the document. For clients who have already received the document with the disclaimer language in it, we will ask you to send a letter to those clients advising them that the disclaimer language has been removed and that you will not seek to rely on the clause. So what can you do right now? The continual theme today is to review your current documents. We recommend that you complete a self-assessment. You should also review the documents that you provide to investor clients. Please look specifically for language which purports to limit your liability, is consistent with your registrant obligations, attempts to shift your responsibilities, or which seeks to protect the firm. As we've said today, please have a look at your documents with a fresh set of eyes. Once you've reviewed your documents, if you identify any inappropriate disclaimers, then take action to rectify the noncompliance and make sure you document the action you've taken. So moving on, today we have spoken about particular topics where you are directly communicating with your investor clients. I would now like to talk about your back office compliance system. It is very important that your compliance system supports your communication with your investors, clients, and your obligations under securities laws. As Alize mentioned at the beginning of our presentation, we expect market participants to conduct themselves in a manner that is consistent with the principles of securities regulation. This requires market participants to respect not just the letter of the law, but also the spirit of the law. You have an obligation under Section 11.1 of National Instrument 31-103 to establish an effective compliance system. Your compliance system should provide reasonable assurance that you are complying with securities law and also manage your business risks in accordance with prudent business practices. Under securities law, the ultimate designated person and the chief compliance officer of a registered firm have certain obligations. The UDP is responsible for promoting a culture of compliance and overseeing the effectiveness of the firm's compliance system. Therefore, among other things, the UDP should be promoting to everyone in the firm the importance of good communication with clients. The UDP should set the tone for what good communication with clients actually looks like. The UDP should also have good knowledge of how the firm and its individuals actually communicate with clients. They should ask questions and be informed of the communication activities with investor clients. The Chief Compliance Officer is an operating officer who is responsible for the monitoring and oversight of the firm's overall compliance system. The CCO should continually monitor and report on all of the internal controls the firm has established to manage communications with investor clients. How the firm and its individuals are communicating with investor clients is a very important area that the CCO should always be monitoring. I'm sure for most people here today, you are already very familiar with the key elements of an effective compliance system. As you can see on this slide, a compliance system has 4 specific elements: visible commitment, sufficient resources and training, detailed policies and procedures, and detailed records. For the purposes of today, please narrow down your thinking slightly. And by this I mean, when you look at each element, think about how you're actually using the element to support your management of client communication. For example, for the visible commitment element, consider what does your CCO do on a day-to-day basis to monitor how registered individuals are actually communicating with clients. For the resources and training element, what training does your firm provide to registered individuals on how to communicate with clients to collect their KYC information? For the detailed policies and procedures element, does your policies and procedures manual actually identify all of the times your firm is communicating with your clients? Does the manual reflect how the communication actually occurs? And if you are using electronic delivery of documents to clients, do your policies and procedures reflect this? For the detailed records element, what records does your firm maintain about client communications? Do you have a copy of all the information that the client has provided to you? Do you have a copy of all the documentation you have given to your clients? And lastly, do you have a copy of the relationship disclosure information you delivered to your clients? These are just a few examples which come to mind when thinking about how an effective compliance system can support your client communication. Another area that you should consider is whether your compliance system adequately addresses your communication with vulnerable investors. You should assess your firm's business model and policies and procedures. For example, your firm's policies and procedures should provide for the training of firm employees, including advising representatives, associate advising representatives, dealing representatives, and compliance staff on communicating with senior clients, suitability issues for senior clients, identifying signs of elder abuse, and identifying signs of diminished capacity regardless of age. Also, you should provide for an internal process for escalating issues identified with vulnerable investors. Consider implementing policies and procedures which stipulate a requirement for clearer and more detailed communication with vulnerable investors. You may also need to modify the documentation that you give to vulnerable investors. For example, providing documents with enhanced font size and plain English language. It is very important that you document your communication with vulnerable investors. On the next 2 slides, we have provided a few observations on what an effective compliance system which supports client communications can look like. In the interest of time today, we won't go through these in detail, but we are happy to speak about this further at the end if needed. So through today's session, our aim is to give you some guidance on how to communicate with clients in a compliant manner. As I mentioned, an effective compliance system supports your communication with clients in a compliant manner. We need to mention that there are consequences if you do not have an effective compliance system. Firstly, there are the business consequences such as client complaints, lawsuits, and the loss of clients. Secondly, there are regulatory consequences. Where we find that you are not in compliance with Ontario securities law, we will take regulatory action. The regulatory action may include a recommendation to impose terms and conditions on registration, and in more serious cases, a referral to our enforcement branch or a recommendation to suspend registration. There is a very good chance that when we conduct a compliance review of your firm, in some aspect, we will be looking at how you communicate with your clients. It is safe to assume that all of the areas we have spoken about today are areas that may be reviewed when we conduct a compliance review of your firm. So with that being said, we have a few ideas of what you can do right now. You could perform a self-assessment of your internal controls, looking at your risk areas, your policies and procedures manual, and your available resources. If you have previously identified deficiencies in your dealings with investor clients, take action now to rectify and document the action you take. Review your client records and consider if they are accurate, complete, and accessible. Are your client records organized so that information can be found and used when needed? Every year, the CCO is required to provide an annual report to the board. Plan to always include an assessment of your communication with investor clients in the annual report. And lastly, identify how your Chief Compliance Officer can stay up to date on compliance and regulatory topics which directly impact your investor clients. This concludes our presentation today. We hope the guidance we have provided is helpful and usable in your firm. On the next few slides, we have provided links to resources on the topics of today's session. There's a lot of information available on the OSC website as well, and we encourage you to review it.